Sticks and stones may break my bones, but names will never hurt me. You're all familiar with that aphorism. That's not true. Words can hurt, words can insult, words can be offensive, but that doesn't mean that the government should be able to restrict all such speech. The First Amendment does not include the right not to be offended. In fact, the First Amendment is about offending people, offending politicians, calling them out for disagreements, improper behavior, that sort of thing. On a college campus, in particular, debate and speech is incredibly important for the intellectual sharing of ideas, thoughts, education. The point of going to college, going to university, is not to be safe. It's part of the maturation process to expose students to new ways of thinking that they may not have considered before, that they may think are offensive, that they may think be insulted by. But particularly on college campuses, we should not be restricting speech unless it's really creating danger or some sort of imminent emergency where physical harm is threatened, that sort of thing. Me and my colleagues are going to argue that free speech, that hate speech should not be restricted on campuses for that reason. We are going to be ably opposed by the other side, and I have the pleasure of introducing them. Professor Thomas Crocker teaches at the law school, where he teaches constitutional law and free speech and democracy. He went to Yale, where he was book reviews editor of the Law Journal there, and editor of the Yale Journal of Law and the Humanities. And he clerked for a judge on the 10th Circuit. He also has a Ph.D. in philosophy from Vanderbilt and a master's degree in philosophy from the University of Wales. He has published on these issues, on constitutional issues, including a book, Overcoming Necessity, Emergency, Constraint, and Meanings of the American Constitutionalism, which received the 2020 Palmer Civil Liberties Prize. Emily Mathias is a Belinsky Fellow and a PhD candidate in the philosophy department here at the university. She's also an intern for the Dean of Students. She has a Bachelor's of Arts in Philosophy and a Master's of Arts in Philosophy. And she's interested in ethics, philosophy of language, and philosophy of higher education. She's worked on a number of legal issues in the Division of Student Affairs and Academic Support, on Title IX issues, substance abuse prevention in education, and she's a non-voting party to the Staff Senate Bylaws Subcommittee, and she's published on insults and lectured on First Amendment and academic freedom and freedom of expression, at the National Association of Student Personnel Administrators Conference. And if I can separate the third page. Chloe Satsker, is that right? Okay. Is a 3L here at the law school. She's associate editor of the Law Review, a member of the Community and Engagement Task Force, and a legal writing tutor. She graduated from Clemson. We won't hold that against her. With a degree in Spanish and International Business, and she was sustainability chair for the student government. And she has, after she graduates, she'll be working at a firm in Charleston. All right. So back to the proposition at hand. The First Amendment, as you know, says Congress shall make no law abridging freedom of speech or of the press. And just to set the basic parameters, that through the 14th Amendment, that applies to states and local governments. And therefore, we are limiting our debate here to public colleges and universities. Private colleges and universities also face these issues, but it's a different paradigm because they are not directly impacted by the First Amendment or covered by the First Amendment. In terms of the First Amendment, there are various forms of speech that the courts have held are not protected. And I just very quickly want to mention them. Incitement, true threats, fighting words, obscenity, defamation, fraud or perjury, and speech integral to criminal conduct. Each of those has been, most First Amendment issues, has been heavily litigated over the past 50 years or so, or longer. And all those exceptions are, to speak about them generally, are limited in scope to specific requirements which generally center on specific harms caused by that kind of speech. Just to give a pertinent example, which is pertinent to the discussion today, in a case called Brandenburg versus Ohio, the Supreme Court held that a Ku Klux Klan member at a Ku Klux Klan rally who said he was going to seek revengeance against the government did not constitute a incitement because he had no means and no immediate plans to actually do something about that. That, however, given who he was and the setting at a cross burning, that could be considered hate speech. I'm sure other things he said at that event were hate speech. But what the court focused on, a unanimous per curiam decision, was, including, by the way, Justice Thurgood Marshall, that there was no immediate threat of violence, and that it was therefore he was protected by the First Amendment and his conviction had to be overturned. The courts have been consistent on that, even with more direct sorts of hate speech. RAV versus St. Paul involved a teenager who burned a crude cross made up of two chair legs kind of taped together on the lawn of the only black family in his neighborhood. Clearly a hateful message, let's put it that way. And he was convicted under a statute that St. Paul had against hate speech. His conviction was reversed by the Supreme Court on the grounds that the First Amendment does not allow government to discriminate on speech on the basis of its content. A few years later, they actually did hold that a cross burning could be prosecuted if the criminal act, the criminal statute, included intimidation as a requirement, as an intent of the speech. So it's not the speech itself that the Supreme Court has said can be prohibited. In fact, they've said quite the opposite. It's the intimidation, it's the effect of that speech. And maybe that's just a lawyerly distinction, but that's what the key is to understanding why campuses should permit and be required to permit, or more precisely, not be allowed to limit hate speech, because it's discrimination on the content of the speech, number one. Number two, there's also a problem of defining what hate speech is. What I might consider hate speech, you might not. Our host talked about controversial speech. And hate speech can be controversial speech, but controversial speech isn't necessarily hate speech. So it's making these distinctions can be incredibly difficult, especially, they're hard enough for lawyers and judges. College administrators, deans, etc. It's not something that they are well versed in making these distinctions, and therefore it's likely that they're going to be more restrictive than the law allows and more restrictive than necessary. Because, face it, a school administrator wants to limit problems, let's put it that way. But that's what a university is all about. A university is about debate, discussion, learning, exposure to things that you hadn't been exposed to before, and that is why hate speech should not be restricted, because there are too many pitfalls and too much opportunity for restriction of what we would, I mean, I'm reluctant to use the term legitimate speech, but speech beyond what might, the definition of hate speech is flexible, and that's the problem. Too many people, what's hate speech to me might not be hate speech to you, and vice versa, and that is a problem with policy when you have such flexible definitions and flexible when you're sanctioning something or punishing something or prohibiting something. I ran out of stuff to say. That does not mean we are endorsing harassment. That does not mean we are endorsing actions against another, between students and faculty, whatever the case may be. There are, as I did outline, there are types of speech that can and should be restricted. But it has to be based on the danger and harm of the speech, not to ego, not to persona, not to insult, but to the safety, security, and operation of the university. Those are the only restrictions that should be allowed, and those are the only restrictions that the First Amendment permits. So we present the proposition that hate speech should not be limited on college campuses, and we look forward to the other side and having a robust debate on that topic.